The Minnesota legal case I found was complaint file number 11/005C, which occurred in Prez, Minnesota, ISD 484, and the complaint was filed in October 11th of 2010. So the issue was during the 2009-10 school year, the Prez district failed to hold IEP meetings to discuss students' needs for alternative states assessments prior to determining which special education students would be given state alternative assessments. And the complaint was actually a special education teacher within that district. So the findings of the facts: state assessments were administered to all public school students. In spring of 2007, Minnesota offered the Minnesota Test of Academic Skills, which is the MTAS, which is the alternative assessments based upon alternative achievement standards and eligible special education students in reading, math, and in science. In spring 2007, they offered reading and math, and in spring 2008, science was offered. The district administered the MTAS assessments on 14 students who were on an IEP. So, of those 14 students, the complaint investigator reviewed the files of those students who took the MTAS in one or more subject areas. So, after the complaint investigator reviewed everything, they found out that the district was not in compliance with their documentation. So, for instance, documentation in an IEP to take alternative assessments, which was the MTAS, only 8 out of the 14 IEPs stated this. The explanation in the IEP showing that the student needs alternative assessment had 6 out of the 14 stated in their IEP, which is less than half of the students who were taking the MTAS of those special education students. Another form of documentation for the alternative assessment: 2 stated in their IEP that they had parental agreement, and 2 had parental agreement after the assessment was offered to the student, but before it was administered. And lastly, 2 files contained absolutely no documentation for alternative assessment. In the conclusion of the legal case, kind of reviewing all of the facts that I just gave you, 8 out of the 14 files had IEPs documenting alternative assessment. 6 out of the 14 files met documentation requirement for alternative assessment. Like I said before, that is less than half. 4 out of the 14 files had telephone logs or IEP agendas that were documented for the parental consent, but they did not meet requirements for the PWN. They did not send a PWN home documenting that they talked to the parent and they were making changes to the IEP. So there was nothing in their folder stating that parents agreed to those new terms. The special education staff did not meet due process requirements, which led them to having to take a training that was held on August 24th of 2010. And along with that training, they also had to provide a document showing everything that they learned within that training, that they understand the due process paperwork and they know what are the requirements, and that they will provide those within all the IEPs that they do. So the decision based on all of the information and the facts is that the district violated when verbal changes were not documented within a PWN notifying those parents of those specific changes, as well as they also violated when determining which students should take alternative assessments, the documentation as to why that student needs to take alternative assessments, the accommodations needed for that specific student, and why alternative assessment is appropriate for that specific student. Then based on those decisions at the school, a corrective action needs to be taken place. So the district needs to take the following actions in order to make sure that they are going to be in compliance with everything. So the high school teachers need to take the MTAS state webinar. Teachers have to have a copy of technical assistant documents within their classroom. The IEP team needs to make assessment determination and provide why regular assessment is not appropriate for that specific student. Proper documentation, basically that they were participating in a training, and within that training it needed to be followed by the director of special education providing all of those special education teachers within that training. And the district needs to set up an internal system to notify teachers of any changes to assessment guidelines to make sure that they understand everything that might have been changing.